Elizabeth, thank you so much for being with us. I'll ask you to introduce yourself very briefly again first, and now maybe from the perspective of that topic that we're going to discuss, the Anti-Corruption Directive. Are you maybe still muted, Elizabeth? Because I cannot hear you.
I'm mute. Yes.
Yes.
Voilà. Thank you, Jan. Yes, I'm a partner at Liberius Law Firm, which is a boutique law firm based in Brussels. Before that, as said, I've been in your seat as in-house lawyer for decades in international company. As you can hear, I am also French. I cannot hide it.
There's no need to hide. Thank you so much for being with us. My name is Jan Stappers. I'm a lawyer from the Netherlands, and I've been for almost 15 years in the GRC space, most recently with Mitratech. Mitratech is one of the global leaders in GRC software solutions. So whether it's hotline or third-party due diligence or policy or training, basically any GRC pillar from a software perspective, we cover that. And why are we here on this webinar? It's of course because of that new law that entered into force little less than 2 weeks ago, the Anti-Corruption Directive. We have a little bit less than an hour to discuss that topic. It will be enough to give you high-level insights, but it's going to be a repeated topic that we're going to come back on each now and then, because of course, this is a directive. It's still developing at member state level. What are we going to discuss during today's webinar? We will discuss why this directive actually exists, why at this moment, what it means for organizations, what actually exists in the directive content, and then where you really need to start building and doing something, because this is not a nice to have. This is a must have for any organization operating, not just headquartered, operating in the European Union. And then Q&A is mentioned as a last bullet point, but please do not hesitate. We can actually see those questions coming in live. Already a couple of them came in live, so thank you so much for posting them. We'll try to address as many questions as possible. And in order to make sure that you're actually there and actively participating, we want to launch a first survey or poll slide, if you will. I hope you can see it in the screen. How confident are you that your anti-bribery and anti-corruption program actually meets current EU standards? So the poll is open. Elizabeth, what do you expect regarding results of this poll, please?
I'm very curious, Jan. I don't know what to say. I'm not sure that it was on the radar screen of many companies this day, but I hope it is. Let's see.
There we see results. By far, the biggest group is stating that they, or we, from the perspective of the people voting, are largely compliant, but still enhancing certain areas. That's nice. That room for improvement gives me motivation to actually carry on with this webinar. There's apparently still something to learn. That's very nice if you're presenting on a new development. We'll have 2 more poll questions for you throughout the webinar, but this gives a nice impression. This is not 100% a novel audience, of course, to the topic, but also not 100% mature audience yet. Back to the slides. The risk landscape. If we discuss where this regulation is coming from, where it actually originated from, we have some background for you. Of course, many people know that the fact that there is corruption, wrongdoing, it costs us as a society a lot of money, and we Dutch people are not the only ones who don't like to spend money, especially if we get nothing in return. And the sums are really hefty. It's between 180 billion and almost 1,000 billion, I don't even know how to say that, per year. So up to 6% of GDP, according to the European Parliamentary Research Service. That is the cost of corruption. As we want to use that money for more fun things as a society, we want to avoid these kind of costs. There is now a minimum level of rules, of regulations determined across the European Union. And that is the directive. That is in a nutshell. Elizabeth, can you be a little bit more elaborated regarding what the current situation is and where we're moving towards, please?
No, thank you for giving some societal background, because I think it's important to understand why a law has been elaborated actually for years by the European institution. Today, what we've got is, as many of the audience now, we've got different member states with different regulation covering different aspects of corruption and bribery. So it creates some uncertainty, especially in our global world. You need to have a more European enforcement, and we don't have that today. So with the directive, the objective is to obviously harmonize the offenses and the fines, which give more legal security, and improve the cooperation between the enforcement bodies in Europe.
Yeah, thank you so much. So that is the background. You also see that bottom bar that in 2022, a great percentage of citizens and businesses actually perceives corruption as an issue. So it's not just the numbers telling it. People and organizations realize or perceive it, that this is a serious issue. And that brings us to poll 2. Because we'll be looking into that anti-corruption directive now a little bit more in depth. How familiar are you with that regulation? Please let us know. I'm very curious what the results will be. It's very new. It's less than 2 weeks old now, but of course you could have followed it in the time, the run-up to the actual entry into force. I'm very curious what organizations, what individuals have been using their time for. Have they been keeping track of the European Commission's developments or not? Answer,
Wow.
a lot of people say, well, I actually haven't read it at this moment. You're totally forgiven for doing that. I hope you've been doing more exciting things than reading legal text, but it's about time to actually start looking into that text. More than half have not read it yet. Thank you so much for submitting your votes. So let's take a first step at what the risks are actually regarding the directive. And we wanted to, of course, start with that big stick to maintain the attention of the audience. There are also carrots, of course, because eventually it hopefully will battle that corruption and wrongdoing. But what is the big stick? What is the risks connected to this topic? Elizabeth.
Yes, I think this slide, for most of the in-house lawyer, it speaks for itself. In detail, obviously, in terms of risk, you've got the legal risk, because here with the directive, you've got criminal liability involved with imprisonment and fines for the company. You have also the risk of exclusion from public tenders. The other key risk identified is the reputation of the company. We all know that in this type of cases, the big risk, also the side indirect risk, is the loss of trust of consumer, customer, I mean, all the environment. And you will have to deal with a lot of media scrutiny, which is always disruptive. Then the financial risk will go into more detail after. So we are here with a fine which can, the directive is a minimum. I wanted to emphasize that, and we'll see that further. But you are from 5% of the global turnover. And I insist on global turnover. It's not just a European turnover. We'd also side measures like asset confiscation. And it speaks for itself. And you know all this, when you are in this type of crisis, you've got operational risk, disruption from investigation, because suddenly the company is just stopping and trying to answer to the investigator.
Yeah, and maybe on that topic, these are significant big stakes, reasons to actually really start working on compliance with the minimum framework that the directive is. As Elizabeth said, it can only become more strict if the member states transpose, or equally strict or more strict if the member states transpose correctly. They cannot say, wow, some parts we will not put into action, because that would be a breach of the European law. So it can become more strict, and actually it makes me think very much of the GDPR, the data protection regulation, which of course had direct applicability, but also very hefty fines there that we actually saw being imposed on some organizations. So there were millions and millions paid in penalties for that regulation. If we look at this directive, Elizabeth, do you expect that there's a similar risk for organizations? And not even considering criminal liability, which is not nice, the reputational aspect, which is not nice. But if we look at those penalties, do you think that there is an actual chance that member states, the relevant authorities, would ever impose penalties for breach of anti-corruption laws?
Yeah, I believe so. I mean, corruption is really perceived by the European institution as really something critical to tackle. And like GDPR, at the beginning, we did not see a lot of fines, and step by step it came. I think we are maybe in a higher risk level in terms of societal risk, and people expect that corruption is a risk which is tackled by the authorities. So yes, I see really a real risk.
Yes, and I also think there might be a bit of a geopolitical shift from less enforcement in the US and then European agencies that think, okay, in that case, we can be more in the spotlight. I think there might be a little bit of that play as well. But definitely a big stick, something to work on as an organization. So we don't want to just scare you with this messaging. That's why this webinar still takes twice what it already took. We still have about 40 minutes left. We'll be discussing what you should actually do. What are next steps? First, about the timeline. You'll see that the directive was published in May 2026. Of course, there was a whole procedure prior with a lot of lobbying behind the screens because, of course, we're in the European Union. This is happening. But eventually, we landed at a final text that entered into force on May the 31st, so very recently. And then plus those days that you need to have it published, official journal, and that lands us at a transposition deadline, which is June, if I'm not mistaken, actually it should be June the 20th, but it's in June in 2028, because member states have 2 years for transposition. And transposition means, of course, to transpose the EU level text into national laws. And then it becomes a little bit more complex regarding anti-corruption strategies that have to be published. And then eventually there will always be a report looking back at how the law is delivering, how the transpositions are delivering. And then there'll be a second kind of analysis moment, but that's very far ahead. I think we should first look at the date of the transposition. Elizabeth, why is this not a moment for the attendees to say, great, I just got 40 minutes back from the presenters, because the deadline is 2 years out still. I don't have to do anything. Why is that not the right approach?
Yeah, first, maybe for the non-European attorney, maybe they need to understand what's going to happen between these 2 years. So the member states are going to implement the directive in their country within these 2 years. So we'll have to follow how it goes, and Mitratech will do a tracking, and we'll do that with Mitratech, tracking of the transposition by member states. Then back to your question, Jan. Yeah, I mean, you don't change company. I'm not saying that the attendees have to change the company culture, but there is a lot of newness in this directive and a lot of changes which I think they will see and requires change maybe into their compliance program and look at the thing a little bit differently with respect to their European business. So it's some work. We know that in companies, sometimes you need time, you need budget, and so you need to plan in advance in the budget to look at this in detail.
Yes. So exactly, and I really want to pause here for a moment, because a lot of organizations would say that we already have anti-corruption measures in place. We have a policy. I don't know where it is, but we must have it somewhere. That is not what the directive requires from you, and we'll look a little bit more in depth on that topic. It really takes time to create a culture and an environment which is compliant with the law. And in our experience, depending on the complexity of the organization, 2 years is not even that much time for you if you still need to connect all the dots regarding all the obligations of the directive. By the way, I need to give full credit back to the people who made this slide. This is correct. May 11th, the directive was published, and then 20 days later it entered into force. So that is exactly May 31st. So no mistakes on this slide. Copy pasted. This is 100% correct. And indeed, as Elizabeth said, we have now a tracker online. It's already online now, because what's going to happen, you'll have all the member states -1, because Denmark is excluded from this directive. All the member states in the EU, all the other member states will transpose. And what does that mean? We will see a total patchwork, at least that's what we expect, of slightly or very different transpositions. So we have that resource online. We'll keep it live so that you can directly and at all times see what the status is per member state. Because as various questions that are coming in are addressing, I am not headquartered anywhere in the EU. Do I still fall within the directive scope? Yes, because it doesn't have any threshold regarding turnover or number of employees, and you are within scope if you perform any economic activity within the EU. So where your headquarter is not really relevant. This is the long arm of Brussels, and it will very likely find you. If we look at the key changes introduced by the directive, and that goes, of course, to the argument of we already cover anti-corruption. We have so many interesting policies and trainings and awareness programs in place. We are probably fine. Probably not, because there are a lot of changes introduced by this directive. Elizabeth, could you please take us through those?
Yeah, I'm not going to go through all the list, because as you can see, the list is long, which says a lot. What I want to insist on is that the directive set minimums. So this is the minimum, and then the country can go further depending of what they want to do. The important other point is that here you have criminal liability for individual. So it's not just about company liability. I pay a fine and I'm fine, sorry. But it's also for individuals, they are in scope. The fines are generally increasing compared to what is in the regulation various member states today. Then you've got a concept which exists already in some regulation, but which is not criminalized and harmonized in the EU today. It's the concept of trading in influence. So we'll go further later in the slide. And yeah, you've got some mitigating circumstances which are listed, and compliance program is one of them. So I suggest that we go, because I see the question are actually questions that we are going to answer in the rest of the presentation from what I've seen. Yeah.
Let's move on. We still have a little bit more than half an hour left, so we're going fantastic on time. What's actually in the directive? Well, and that is one of the very important aspects is that extra territorial scope, because this is where a lot of people realize, okay, we are not headquartered in the EU, but are we still in scope? Yes, you are. So please, Elizabeth, this is becoming very serious.
Yes. So this, the territorial scope sits in Article 18. Article 18 is divided in two parts. You've got the one part which is mandatory, and then the other part which is optional for the member states. So the member states have the possibility to go further what is in the first part. So if the offense is in whole or in part within a member state, then the directive applies. If the offense is done by a national of a member state, wherever and regardless of the location of this individual, the directive applies. And obviously, if the offense is done by a company established in a member state. However, don't forget the optional possibility for the other member state, because they can enlarge the scope to habitual resident in a member state, offenses which are against the member state's national or resident, offenses for the benefit of a company established in the member state, and offenses for the benefit of a company doing business in the member state. So for multinational company, the practical consequence is that the jurisdictional exposure must be assessed not just by where the conduct occurred, but where the company is doing business. To this, I would like to add something about the recital 33 of the directive, which it's not really clear to me, create a digital nexus. I'm going to quote this recital so you can make your own opinion, which says that member states may also extend jurisdiction to offences committed via information system used on their territory, including cloud infrastructure. So this enlarged enormously the scope of the directive. Two notes on this, because I've seen comments where people were already interpreting this wording as like there is a digital nexus, whatever. I would like to make sure you know that this is in the preamble, so it's not in the core of the text of the directive, and it is an option for the member state. So the point to follow, I believe, is to see what the member states are going to do based on this recital.
This is the moment that you should start thinking, maybe I should get legal advice. And it's handy because you know exactly who to contact with this webinar. This is quite complex. But on the other hand, the directive provides a lot of insights. Also, it does not provide some details, for example, on the questions that are coming in, whether the directive will apply to large profit organizations or also NGOs or governments. That is something that the member states will decide upon in each transposition. So indeed, it will create a very creative, sometimes patchwork of national transpositions. If we look at that definition of public official, Elizabeth, could you take us through that definition, please?
Yes, I've made sure that we have a slide just on this, because public official, we think we know what it is. But here really the European regulator has made sure that it's a functional concept and a very large and broad definition. So the public official is defined in Article 2 of the directive and also in the preamble. And I would say that there is really, you see from the slide, it can apply to international organization, international court, any person exercising public function even without formal office in a state-controlled company or private company performing public function. And I really want to be sure you note this, because you may think you don't speak to somebody which is considered as a public official for the application of this directive, but actually if they work, they perform public function, but not in a public body, they can still be considered, as per this directive, as public official. And you've got also, especially quoted in the Article 2, arbitrators and jurors.
This is again a complex definition. By the way, on that topic of why Denmark is excluded, I had the time to check that myself live, because I just didn't know it by heart. I knew it was excluded, but why? I can tell you it's, now we go really into European law history, 1992 Treaty of Maastricht. Maastricht, I should actually pronounce it in proper Limburg Dutch. Denmark had the right of not being bound by a couple of topics regarding European law. And it happens to be that anti-corruption is one of those topics. So Denmark not bound by the directive. They have their own anti-corruption laws, and all the 26 remaining member states bound by it.
And to add a note, if I may, on Denmark, I don't know if you follow the Corruption Perception Index, and I encourage the audience to look at it. Denmark is quoted as really the country with the highest standard. So they are number one. So that's maybe why they think they don't need to join the crew of the other member states.
And one member state less to keep track of regarding liability under this directive, at least. If we look at that other subtopic, the offenses that are applicable to private and public sectors, and these are quite a lot of articles. There are 5 core offenses. Elizabeth, could you please take us through those?
Yes. I actually, if I may, not going to go through each of them, because I will insist on trading in influence, misappropriation, and concealment. So again, these offenses, the one you see on the slide, they are the one applicable to private and public sectors. You have also offenses which only apply to public sector. So trading in influence. So what is this new beast, if I may say? It's paying or receiving an undue advantage. And we look after what is the definition of undue advantage, to influence a public official. So this is not about money. First, that's the key one. It can be money or no money. It can be real or not real influence, because whether or not the influence was real or succeeded, you can be in the scope of this Article 6 of the directive regarding trading in influence. So in the preamble, because I think many people must think, what about all the advocacy business that we've got in Europe and in other countries, obviously. And are they, because advocacy company, public affairs, PR, their main purpose is to influence regulators, right? So in the preamble, in the recital number 16, they say, and I will quote also again, that trading in influence should not be considered as illegitimate activity, see if it's legitimately influence public advocacy. So it answers our question, it doesn't answer our question. So I think the way to understand that is, if you have a contract with public affairs companies, if it's done in a transparent way, if there is, for instance, no success fee to get, for instance, a license, that's the key point, is to see how the remuneration and the financial scheme of your contract has been made. and maybe it's the time to look at this type of contract and review whether the way its structure could be interpreted as entering into trading in influence. Then on misappropriation. Misappropriation is basically using assets or of the public body in a way which is not intended to be done. So you use funds or property for another purpose. What we should note here is misappropriation. Strictly speaking, it's only for public sector. However, there is an option for member states to add misappropriation in their regulation. So that's why I added this misappropriation into this slide, private and public sector. But just note, it's an option. To go back on the definition, so there must be a financial damage for the company or the public authority to qualify as misappropriation. In another article, which is not in Article 5 but somewhere else in the directive, it states that the member state have the option, in case the misappropriation is below the threshold of 10,000 euro, to not to just make sure that misappropriation, that the offense is not qualified as misappropriation. So it's an option. And then I think we should read misappropriation and concealment together, because concealment is obviously the fact to hide what has been misappropriated, or a bribery, for instance. It can be fictitious consultancy invoice. So for me, they really work together. First, if I may very simple, you steal and then you try to hide what you have stolen. So I would think that if there is misappropriation, if there is bribery, there is also concealment after.
Those are 3 of the 5. So indeed, bribery and obstruction to justice, there are other offenses, but we'll look into it maybe in a follow-up paper, because we also get questions on those topics. We will address them. If we look at the public sector specifically, because I know that also in the audience there are some attendees from the public sector, those 2 offenses, could you please discuss those, Elizabeth?
Yes, the first one is unlawful exercise of function. So serious violation of law by a public, which is out of their duties. And I would like also to insist on the enrichment from corruption offense, because this one is a little bit hidden, I think, in the directive. It's basically the fact there is being an offense, and another public official, so it's public official to public official, knows that actually some money has come from an act of bribery, and is making benefit of that. So it's a little bit, it's going further than just the direct bribery, and that's why we should not forget about this offense while looking at the case.
Yeah, thank you very much. If we look at the undue advantage, it is not defined in the text of the directive itself. We still get guidance from this recital 13. Why did you want to include this topic, Elizabeth? Because,
I mean, as a practitioner, I know that many times the question is, is it a permitted gift or not? And as a practitioner, you want some legal certainty. You would like to understand what's the value, what's the permitted value. Is it 50 euro, 300 euro? And is it only money? Is it not only money? And the undue advantage wording is used many times in the recitals, but also in Article 3 and 4, which relates to bribery, and in the article related to misappropriation. And so the difficulty is what does it mean? And the European legislator has obviously did not want to really give a definition. It's more a concept, and this whether there is an undue advantage has to be looked depending on the context. And what to remember, however, so it can be money or non-money. So you don't have to have a concept of money and value. For instance, promising a position or giving access to some very sensitive information can enter into an undue advantage, although there is no money again. What is not undue is, and I'm back to the comment I made about the advocacy sector. If it's permitted by law, then it's possible. And if it's a minimum gift, although, again, there is no value related to what is a minimum gift. So there, as a compliance officer, you have a major role into looking at this and see, evaluate, assess, depending on your business, what's permitted or not, and to provide guidance to your to the people, to the employees.
I'm actually looking forward to seeing how this develops, because it will be a very interesting study of cultures also. What is an advantage, what's an undue advantage, and what is acceptable, because there's so many, of course, business practice sectors where there are a lot of friends services that apparently have no value but actually represent a lot of value. So I'm looking forward to how the case law will develop in that regard, a very significant gray area at this moment. And then looking at fines, those fines, as you heard, 5% of global turnover, that should be something to really draw the attention of the decision takers, basically everyone involved. How is this threshold, the minimums, how are they playing out? We have 5%, we have 3%. Member states can impose higher fines. Elizabeth, could you please help us out?
Yeah, so here we are in the same area as competition law, for instance, or GDPR. I mean, it's based on turnover, which is not the case today in many regulation, in many European regulations. So it's maybe a new concept for many of the people attending today. And I think the figures speak for themselves. It's a very high minimum fine, and we have to see how the regulator is using this and how the member state will implement that in the regulation, whether they will even increase this threshold.
By the way, one of the questions, what is actually turnover? That is the gross turnover of an organization. It's what you start calculating with. This is by no means net profit. So the text also and EU law in general gives some handles to that. Another very good question, which we'll also address at a later stage. What is actually turnover? We continue. We have a little bit more than 15 minutes left, so we'll speed up a little bit.
Yeah.
Other consequences for companies. It's not just about fines.
Yes, so you can also have side measures like exclusion from access to public funding, disqualification from the practice of a business activity. You can have withdrawal of permit or authorization, annulment of contract. And you see that for individuals, you've got the mirror of those measures and consequences for the individual, but we'll see that further.
Yeah, perfect. Thank you so much. Then the direct liability.
Yeah. So this is a key one, and I think it's the slide is divided in 3 parts because you have 3 conditions which are cumulative to have the company direct liability engaged. So this is the first part of the direct liability, Article 13.1. In the other slide, you see another interesting nuance. So to focus on this one, the conditions are first that the offense was committed by a person in a leading position. And I insist on the concept of a leading position. So this is defined. It's somebody who has the power of representation of the company and the authority to take decision or the authority to exercise control within the legal person. So this is first condition, leading person. The offense was committed for the benefit of the legal person. And so there must be a financial gain. So it's just in the course of the work, it must benefit to the company. So it's really to the company. And the last point is that the person has acted individually or as part of an organ of the legal person, for instance, a board member. And we'll see further that actually the highest the person is, it can be in the company, the highest the liability of the company can be an aggravating circumstances.
Yeah, so exactly. I already moved those slides. Yeah, thank you.
Yeah. I know I have to rush. The second point is really an important one in your practice, because there is a liability of the company if there is a failure to supervise. Failure to supervise is a leading person which failed to supervise. So what is failure to supervise? It means that the failure made possible for a person under his responsibility to commit the offense. And again, there is this concept of the fact that it must be for the benefit of the company. So then it says that compliance programs are critical, because compliance program for the leading the person in leading position, so they understand their responsibility and their duty to communicate properly, to create a culture of ethics in the company, to not accept some behavior, to sanction some behavior, and to really create this culture, because I think compliance is a lot about culture in the company. So training of the leading person, and also this duty of training the employees so they understand. First, they sign the ABAC policy, but just signing an ABAC policy sometimes is not enough. You really need to be sure that they are trained regularly and they really understand what it means, what's inside, and in practice, what's permitted and what is not.
Yeah, the ABAC policy is the anti-bribery, anti-corruption policy, yes. Of course. And another topic, culture. It really takes time to build a culture. Hence, us stressing all the time, start now, not in 2 years from now. Then the next topic, the imprisonment for individuals.
Yeah, the scary one. So, well, you can see on the slide, it can be 5 years in case of bribery. If bribery in private sector can be 3 years, misappropriation, trading in influence that we discussed, concealment, enrichment from own offense, it's 4 years. So these again are minimum, always the same concept. They are minimum. They can be increased by the member state. What we should be careful with, it's not because company's liability, the company is prosecuted, that you cannot have in parallel prosecution of the individual. So when you see that an offense has been committed and when you are in a crisis mode, it's important to also assess what individual can be in scope of the investigation and to protect, obviously, your employees. So when assessing a sensitive situation, try to map all the people involved in it to make sure that you can anticipate what are going to be the consequence of the offense. And then maybe we go to the other slide. I already said you've got this. This is the mirror of the other possible consequences for people, for companies. Sorry, you've got disqualification of holding a public office. Practice, you can be stopped to practice some business activity. You can have a ban on running public office. You can have some permits, authorization, license, which are withdrawal and exclusion from access to public funding. So this is for individuals. So you see, it's really similar to what was in the text for the companies.
Yeah, and so this directive has teeth. The question will be whether the authorities will use them or maybe even make them sharper. Last poll to keep you totally engaged and entertained. How ready is your organization for the enforcement deadline? If we think of 2 years from now, the transposition, of course, will be a little bit longer because some member states will give themselves a little bit more time than that. How ready are you already now? And then A was, I hope, a little bit of a gag. I didn't know there was a directive. I hope no one says that, but please vote. And then we'll look at the results and then we'll continue and we will finish in time. Yeah, this is quite in line with what we heard previously already indicating. I started, but it's work in progress. We are here for you. We have the tracker online. We have the knowledge available. We're also tracking what others are doing. So Mitratech, together with Liberius, will be that source of knowledge on this topic. A little bit more happy topic regarding the Anti-Corruption Directive, the mitigating circumstance. This is a very nice positive hook that the directive offers. Elizabeth, why is this so valuable potentially for the subjects of this law?
Yeah, so you've got 4 in Article 16. You've got the usual one like self-reporting, cooperation with authorities, rapid remediation, and effective compliance program. I insist on the word effective. So, and actually in the preamble, really it's not, they quote window dressing. So a compliance program will be perceived as a window dressing by a court could be ignored. So it's really important to have an effective compliance program. The other point is, and the other point is that it doesn't give you an immunity. It's not because you have a compliance program effective that you've got immunity. It will be a mitigating circumstance which will lower the fines or the result of the investigation for individual. But it's not like the magic thing. I have a compliant program and then I'm safe. It's not the case.
We also have aggravating circumstances, of course. So very briefly on those, please.
Very briefly, so the higher you are in the organization, it's an aggravating circumstances. Obviously, if you have been previously convicted, if there is the benefit also, the amount of the benefit has also an impact on the way the investigation and the result of the investigation. And if it's an organ of the company who has the authority to take decision on behalf of the company or exercise control and as committing the offense, it is even worse.
Yeah, thank you so much. And then we see that there's enhanced enforcement coordination across the EU. And also we see quite enhanced obligations for the member states. The mutual legal assistance, I think, is the one that really stands out, that the member states are under an obligation to share evidence. That is quite a novel development, that they can also perform joint investigations. So we see that there are more officers, more cooperation, and this directive really facilitating that. If we look at the statutes of limitation, we also have a couple of measures that the member states must take into account. Elizabeth, some words on this topic, perhaps?
Yes, I mean, what to remember is the EU regulator has tried to make sure that because of statute of limitation, some cases are not moving forward with the investigation. So you've got 2 periods. You've got the one of at least 5 to 8 years from the offense, and then the second period about from the time there is been the penalties have been imposed. We know that statute of limitation for a lawyer, it's a complicated topic. In many countries, actually, when you start the investigation, the statute of limitation is suspended. And so this is why there is the possibility to have a shorter limitation period, depending of the actual regulation in the country regarding statute of limitation. What is, I think, very key to remember is that when you make an acquisition or a major transaction, the way you look at your reps and warranty and indemnity, please be aware of this very long statute of limitation period.
Yeah, thank you. We have 5 minutes left, so we're doing perfectly regarding time. What should organizations do now? And that could actually be a multi-day seminar or conference, if you will, but we packed all of that into one slide. What are the main points? I mean, people look at this webinar either live or later on. What are the takeaways? What should they start doing now, Elizabeth?
First, they should look at their compliance program today and see whether there is any gap and try to fill the gap. I think insisting on the trading in influence exposure, because it's quite new, and look at, I already say, look at your contract with advocacy, PR, or I don't know what you can have also. And assess your compliance effectiveness. I say that many times. Effectiveness, it's a key word. Be sure that it's not just signing an anti-bribery and corruption policy that and you think that you have a compliance program. A compliance program is more than that. It's something which is alive. It's not a piece of paper. Then we spoke about the extra jurisdictional exposure out of EU. So look at your business, look at who are your partners, look at what business you've got in Europe, and try to assess where you can have a risk with your supplier, with your partner, your distributors, to see whether you have well done due diligence, a back questionnaire, whether you have, I mean, look at all this, update your training program, and the training, I think, I mean, my view should be different whether you are in leading position or not, because of this additional exposure for people with a leading position and additional responsibility. They should really understand their responsibility. Look at your internal control and supervision. There is a reference to the whistleblowing directive in the directive on corruption. So look at it, look at whether it's in compliance, and monitor, obviously, national transposition. You've got 2 years to do that. But as Jan insisted on, it's a short timeline.
Yeah. So bottom line, the directive says, make sure you have hotline, policy, training, conflict of interest, third-party due diligence, all in place. And if you don't and it's not integrated, please make sure that it is, because it must align with all those applicable EU frameworks like GDPR, like Whistleblower Protection Directive. It's not an easy task, but it's doable if you start in time. Thank you. We made it in time. We covered a lot. This link will bring you to the resource on the Anti-Corruption Directive, not just the live tracker, but many other resources. It's not just coming from Mitratech, your GRC solution provider, but also vetted by Liberius, which is a top legal expert who can provide any insights in further legal topics that you might have. Thank you so much, Elizabeth, for being with us today. Thank you so much, audience.